Available restrictions under the Freedom Camping Act 2001. This is just a quick video this week on restrictions available to councils under the Freedom Camping Act. Much is claimed about councils and other stakeholders' ability to restrict freedom camping under the Freedom Camping Act. But what does this really mean legally? Two definitions. Absolute in law means that something must be clear, not ambiguous, clear as to whom it applies, be able to be understood clearly to enable compliance. Intent in legislation means what the goal of the legislation was when it was passed into law. At times this intent can be established by reference to the presenting minister's statements made in Parliament if they are not clear in the legislation. The Freedom Camping Act, FCA, is very clear in Section 5 whom it applies to and where it applies. In summary, it applies to all freedom campers regardless of the mode used, i.e. tents, bivouacs, house trucks, RVs, etc. It also clarifies that this activity needs to happen within 200 metres of a vehicle accessible area and or within 200 metres of a low spring water mark. The intent of the legislation is established, applied to all camping modes and within the described areas while applying to non-vehicle users who may camp, for instance, on riverbanks. And clarifying Section 5, the legislation is absolute and the intent of the legislation is established. Bylaws that fail to include all modes and areas described are therefore non-compliant and unlawful. Councils have no ability under the FCA to designate sites available for freedom camping. Section 11 sets out that councils may only prohibit or restrict an area, not designate areas. Again, this area of legislation is an absolute, with a clear intent established. To understand the reasoning, we refer back to who is a freedom camper and where that happens in order to be captured by legislation. To designate a site would mean a council would need to undertake site assessments, which include waterways and areas not usually assessed by motor vehicles or anyone else, in order to comply with the legislation. It is easier for a council to comply with legislation by declaring an area prohibited or restricted from freedom camping due to identified issues. However, councils still need to comply with the three stated area criteria needed for restriction or prohibition. I call them the 3 Ps. They are to protect an area, to protect access to an area, to protect the health and safety of those visiting an area. These are the only 3 criteria councils and other stakeholders can use to restrict or prohibit freedom camping at specific areas. NIMBYs, protection of nearby businesses, i.e. holiday parks, have no ability whatsoever to restrict or prohibit freedom camping. Official information applications on numerous government departments during August and September of 2021 has failed to provide any evidence that campers that are certified self-contained are posing any less of a health risk than those who are not certified self-contained. Therefore, council claims that it does, and therefore the use of it, is not only non-compliant with BOA, but also non-compliant with the 3 Ps, as well as an inability to apply to all campers as defined in the legislation. The fact that it was also lobbied for inclusion in legislation which failed remains evidence of non-compliance with the intent of that legislation. So where does that leave councils and what restrictions can they implement? Many councils attempt to restrict camping to 3 nights, often for reasons not really clarified. should the reasoning be to align with the self-containment certification requirements, and that would be non-compliant in law, as councils cannot use something that is non-compliant and lawful to make something else non-compliant or unlawful. Other restrictions, such as permitting camping only to certain hours, could be made to protect access to an area during the day, i.e. a boat ramp parking area may be free for campers' use by night, but used by boaties during the day, thus potentially being compliant with protecting access to the area. However, each case needs to be weighed on its merits, while remaining an appropriate and proportionate solution to the issue being addressed. Regardless, the 3 Ps applies at all times and are unable to be overruled by council bylaws or even cassette notices. The progression of law from lowest to highest is simply this: council bylaws, government legislation, district court decisions, high court decisions, Supreme Court decisions. Often government legislation can be overruled or clarified by courts, even at a district court level, often when persons are defending offence notices. The High Court is often called upon by way of prejudicial reviews to decide whether councils or other stakeholders have acted within the legislation or law, but may make decisions as part of other legal proceedings which also clarifies legislation. The High Court decision made in Blenheim late last year, for example, not only clarified the intent of the Freedom Camping Act, but it also remains unappealed by either the applicant or the respondent, which the timeline to do so is now well expired. MBIE recently stated that councils can and often do write requirements into bylaws for which they have no legal ability to enforce. I am sure most of us have seen reports of councils being in court attempting to enforce something which they have zero legal ability to do so. Unfortunately, where freedom camping is concerned, most councils have at best a staff member who may dedicate 30 minutes a week to freedom camping matters, and whom rely on outside organisations to provide guidelines due to them not understanding the legislative requirements of the Freedom Camping Act. Sadly, where freedom camping is concerned, much of this information is provided through local government New Zealand, who in turn rely on a private RV organisation for clarification as a preferred partner of local government New Zealand. Yet said organisation, having very limited legal knowledge themselves, but also running their own narratives. I hope this very quick clarification helps. Any questions, fire them at me. Cheers, guys.